I was attending an event with very prominent Swiss arbitration practitioners, and a question came up. And that was, do we have to apply the European Arbitration Act in our proceedings? And the answer is, of course, that depends. Let us have a look at the scope first. Article 2 provides that the Act applies inter alia to deployers of AI systems located in the EU or whose AI output is used in the EU. First, what is a deployer? Well, that could be you, because according to Article 3, Paragraph 4, that means a natural or a legal person using an AI system in the course of its professional activity. Now, what is an AI system? Article 3 gives a pretty high-level definition, but it basically refers to a machine-based system which acts in some sort autonomously and which generates output from specific input. Thus, that could mean any tool which can perform document analysis or generates or edit texts or even does evidence management or, for example, even if it helps you in decision making. So if you have ever deployed ChatGPT or DeepL, welcome to the club of AI system deployers. Now, what about the territorial scope? Well, we're in Switzerland and not in the EU. But think of a council team of international lawyers or a 3-member tribunal where one of those is based in the EU. Because in that case, Article 2b could even apply a uniform approach, saying that if one of them is based in the EU, the whole tribunal should be regarded as based there. But of course, the Act goes even further. And for the location to be in the EU, it is enough if the AI system-generated output is used in the EU. Now, when is that the case? Imagine one of the parties is seated in the EU or their assets are located there. Could a submission or the award that was affected in any way by AI already be regarded as used in the EU? Okay, so we have established that the EU AI Act may in fact apply to consular arbitrators. What does that mean? Well, you might have heard that the Act applies a so-called risk-based approach. And that basically means that the set of obligations progresses according to the level of risk that the AI system poses to health, safety, or fundamental rights. Most of the obligations to deployers apply to high-risk AI systems. What are high-risk-based systems? Well, relevant to arbitration practitioners is especially Annex 3 and there number 8, where we can see that a high-risk system is one that intends to be used by a judicial authority to assist in researching and interpreting facts and the law, or is to be used in a similar way in alternative dispute resolution. Okay, so I guess we can agree that arbitration is in some form alternative dispute resolution. So Article 6 contains exceptions to this high-risk classification where use of the system does not pose significant risk of harm to inter alia, the fundamental rights of natural persons, including but not materially influencing the outcome of decision making. And such can be, amongst others, AI systems, which only perform a narrow procedural task or merely improve the outcome of a previously completed human activity. So if we were to draft a witness statement with the help of DeepL, are we potentially posing risk to the witness as a natural person? Without going into all the details, you will find these obligations mainly in Article 26. And amongst others, the deployer must ensure that the systems are used in accordance with the instructions. It must assign oversight to natural persons. It must ensure that the input data is actually relevant, and so on and so forth. And very importantly, but hidden in almost the last paragraph, deployers of high-risk AI systems that make decisions or assist in making decisions related to natural persons shall inform those natural persons that they are subject to the use of the high-risk AI system. So wait, does that mean that we actually had to implement the Act already yesterday? I can give you some comfort on that, but only temporarily. Why is that? The Act will apply in stages. Whereas it will generally apply from 2nd August 2026, most of these obligations that I have just referred to will already apply from 2nd February 2025.